Good morning. Thank you very much for joining us today. I'm Rajiv from Fixflow, and we're here for our Q3 quarterly update of legal and compliance matters with our industry experts who will introduce herself in a moment. As always, though, today is for general information purposes only. It shouldn't be taken as or construed as legal advice or official guidance. But if you would like any legal advice on any of the specific problems or challenges or things that you're facing, I'm sure that our guests would be delighted to assist, and details of her law firm will be available at the end of the webinar. And so, Cass, for anybody who doesn't know you, could you please introduce yourself?
I will indeed. Thank you, Raj, and good morning. Hopefully you've had a great summer and that everybody else has as well. It seems ages, doesn't it, since we were last here together? And it's now got remarkably colder all of a sudden. It's September. It seems to happen, doesn't it? As soon as the 1st September rolls around, we start putting the heating on and jumpers and the like. Apologies. So my name's Cassandra Zanelli. I'm Solicitor and CEO at Property Management Legal Services, and I'm remarkably colder this morning than I was yesterday, September.
Thank you, Cass. So today we've got a huge amount to cover off. As we've been doing in recent webinars, and this is with feedback from you in the audience. So if this isn't what you want, please let us know. If it is what you want, please let us know. We're starting with a sort of introductory or primer topic. This is particularly relevant for people who are new to the sector, but also a useful update for people who've been in the sector a while. And then we're going to go through some of the key topics, recent cases, key things coming down the track that are going to change the life of block and building managers. And then we're going to hand over to questions. So without further ado, the very first question, the primer question is, Cass, how do you validly call a general meeting?
Thank you. This is something, as you say, that's come out of the last couple of webinars that we've had, haven't we? Where we've had almost like a bite-sized company law masterclass. And one of the questions that seems to come out from that is how a company goes about calling a general meeting. So we'll explore in the first few minutes just a quick overview in relation to that. Before we do, can I just remind everyone that there is, where we're dealing with private companies and of course our RMCs and RTM companies are private limited companies, that there is no statutory obligation to hold an annual general meeting or an AGM. The obligation to hold an AGM is going to be driven by a company's articles of association or memonarts, as we call them for short. So no statutory obligation, but that doesn't mean that you don't have to hold one, because you'll need to check your memonarts and see whether your memonarts require you to have an AGM. Because if your memonarts require you to have an AGM, then you will need to hold an AGM in accordance with your memonarts. There are various ways in which a general meeting of a company is called. Generally, a general meeting of a company is going to be called by the directors of the company, because a board of directors has power to do so, and they derive that power from Section 302 of the Companies Act. And as I say, the vast majority of meetings are going to be meetings called by the board. What I would say as a little aside is, please do make sure that the board are keeping a board minute of the meeting that they hold, where they decide to call the general meeting, where they pass that resolution to call a general meeting. And of course, as a separate aside, to make sure that minutes of board meetings are being kept for 10 years, because it's a criminal offence if you don't. So minutes, records are very important when we're dealing with company law stuff. So the first way, in answer to your question, is how general meetings are called is by the board, and by the board making a decision. The second way in which general meetings of a company are called is by members, and it's by a member requisition. And members representing at least 5% of the paid up capital of the company, when we're dealing with companies limited by share capital, or who hold 5% of the voting rights, when we're dealing with companies limited by guarantee, where those members get together and meet that threshold, they can requisition, and they have the ability to request that the directors call a general meeting of the company. And we often refer to that as a Section 303 request or requisition, or a member's requisition, but it's Section 303 of the Companies Act that gives that power to members, subject to meeting that threshold and various other criteria that's set down by Section 303, gives them the power to require the directors to call a general meeting of the company. And there are timeframes around this. So The members make their Section 303 requisition. The directors then company has 21 days to decide whether or not that's a valid Section 303 request that's been made. And subject to them being able to satisfy that, then the general meeting itself has to be held 28 days thereafter. So there are timeframes that the company have to respond to a member's Section 303 requisition. And if the company doesn't convene the general meeting, then the members can go ahead and convene it themselves. And there are all sorts of provisions in Companies Act regarding that. The next way in which a company meeting might be called, and this is rare, I have to say, is that the court have ability and power to order a company to call a meeting. So there is that, I suppose, element there where the court can intervene and can require a meeting to be called. There are various requirements that a company will need to satisfy in terms of calling the meeting. So notice will need to be given. There's no prescribed form of notice, but there's certain information that has to be contained within a notice for it to be validly convened. And of course, the company will need to give notice to all shareholders who are entitled to receive it. The ebook that will follow this webinar will set out in some detail the requirements as to what needs to go into a notice, because your notice is going to have the date, the time, including the day of the week, and the place of the meeting. Lots of debate, I've talked about this before, haven't we, about virtual meetings and whether a virtual place is a place for the purposes of Section 311. Exciting lawyer stuff that I won't bore you with in very much more detail this morning, but the notes will, the ebook will set out some further information about what needs to be included in a notice of meeting. There's stuff about proxies that will need to be included in there. If you're passing or intending to pass a special resolution, then the text of that special resolution will need to be in there as well. The ebook will talk about how notice must be given, whether it's to be given in hard copy form, whether it's going to be given in electronic form. There's issues in relation to the length of time for the notice, and also the clear days issue, which sometimes trips people up, isn't it, that you have to leave so many clear days between serving the notice and then the meeting itself being convened. And what we'll do in the ebook is that we'll give an example and put some dates around it so people can use that example and work out what length of notice and what clear days looks like in that respect. There are some resolutions that require special notice to be given, and again, we will deal with that in the ebook rather than taking up too much time in this webinar this morning. And a final reminder, where we are dealing with company meetings, that for business to be transacted lawfully at a meeting, the meeting itself must be quorate. So you need to have the right number of people there who can make decisions in relation to the company. It's a quick run through, Raj, in relation to calling general meetings.
That is brilliant. Thank you very much, Cass, and hopefully that was useful. If it was useful, or even if it wasn't useful, please let us know, because your feedback helps to shape what we include in future webinars. I think it's just as a slight aside, there's been the ongoing debate within property management as to whether people manage buildings, people manage people administer contracts. And I think it's not a one or t'other, it's all of those things. But what's come through in this webinar series so far is that in managing contracts, there's obviously the lease, but do not forget about the Articles of Association or the statutory principles that sort of overlay everything as well. So for the experienced listeners today, I'm sure this is, we're not trying to teach you to suck eggs, but thank you very much for bearing through a primer, and hopefully it was useful. For new people to the sector, hopefully it was a useful introduction.
It is. I jump on my soapbox at this point, as I do from time to time, and I bang on a lot about the importance of reading, understanding and implementing the terms of leases, and we'll talk about that in a moment in the Section 20B case. But it's equally important to read, understand and implement the terms of the Memonarts.
Yep.
They will tell you a lot about how the company is to be governed and what you need to do in relation to meetings. It's important that you not only undertake a review of the lease, but also a review of the Memonarts as well. I'll
Thank
jump off
you.
my soapbox.
Thank you. And I'm looking forward to the audience feedback. As a reminder, please submit any comments, questions, insights via the Q&A button. We've got 15 minutes at the end to go through the themes that are raised by you, and you also help us to shape future webinars. So hopefully a virtuous circle there. And with that, we're going to move on, once I found the right button, to a new Section 20B case. So what do managing agents need to know about West India Key and ETAL?
This is one that I've been promising for a couple of months, isn't it? In the last couple of webinars, I've been saying there's a Court of Appeal case coming very soon. Able to tell you all about it. It's here. We had the decision handed down relatively recently, so in the last few weeks or so, and it's all about Section 20B and the 18-month rule. And we know, don't we, that there are a raft of contractual restrictions on the recovery of service charges. Those are lease specific, so they're driven by the lease and they vary from lease to lease to lease. And to be able to understand those contractual restrictions and so be able to make sure you're complying with them, you need to read, understand, and implement what's in your leases. It's a little mantra. But in addition to those contractual restrictions, you also have a raft of statutory restrictions, and they apply across the board. They're things like identification of landlords. So when your service charge demand has to have landlord's name and address for service within England and Wales. Rights and obligations. So you need to make sure your summary of rights and obs accompany your service charge demand and admin charge demand, remembering that there's different summaries for both. And in Welsh, if you're in Wales, managing properties in Wales. Section 20, where we're dealing with qualifying works or a qualifying long-term agreement, so you need to consult or go and get dispensation. Reasonableness, making sure that service costs are reasonably incurred. Section 19, the 85 Act, and also the 18-month rule. And it's the 18-month rule, Section 20B, that causes the most issues, because if you get it wrong, and you fall foul of the 18-month rule, then service charges become stale. Stale service charges are unrecoverable. So it's important that you don't fall foul of the 18-month rule. A lot of the other stuff I can put right. So the effect of non-compliance with identification of landlord, for example, or not serving the rights and obs, you can correct that because you can serve a valid demand, or you can serve a demand that has the rights and obs which accompany it. And when you do so, those service charges become payable. If you miss the 18-month rule, then like I say, the service charges become stale, they become unrecoverable. And you probably have, if you're a managing agent, quite an unhappy client at that point. And we have, I'm sure, Roger, that you're familiar with a load of these, lots of cases through the courts and tribunals that are essentially cautionary tales, where landlords, and for these purposes, landlord means the person that's entitled to enforce payment of a service charge. So lots of cautionary tales where landlords have got this wrong, where they have failed to comply with either those contractual restrictions or statutory restrictions, or in some cases both. And as I say, sometimes we can rectify it, put it right, the effect is suspensory, but other times, and particularly for these purposes, the 18-month rule, Section 20B, non-compliance is fatal to recovery. So if you don't comply with Section 20B and don't realise or correct it quickly enough, I think that's the key. Key obviously is to comply in the first place, but if you haven't then realise quickly enough and correct it, then those service charges become stale. Stale service charges are unrecoverable. And there is an overlap between contractual restrictions and statutory restrictions. And that's what West India Key looks at, and it follows some other cases that have looked at a similar kind of thing as well. So Section 20B imposes a statutory time limit on making demands for service charges. So it imposes a strict, really strict time limit of 18 months. And that 18 months starts to run from when costs are incurred. And we have lots of cases about when costs are incurred for these purposes. But for now, let's just keep it simple. 18-month clock starts to run from when costs are incurred. And if more than 18 months elapses between costs being incurred and a demand being made for payment of service charges, service charge is stale, leaseholder doesn't have to pay. And it's recognised that the leaseholder would have a windfall in those circumstances. Now, there is an exception to that. You can stop the 18-month clock running, and you stop the 18-month clock running by serving what we commonly refer to as a Section 20B2 notice. And it's Section 20B2 of the 85 Act. And Section 20B2 enables a landlord, which again for our purposes is the person that's collecting service charges, to essentially put a lessee on notice that costs have been incurred and that the lessee is subsequently going to be required under the terms of the lease to contribute to those costs by means of payment of a service charge. You do have to give your Section 20B2 notice within that 18-month period, but if you can't get your demand out, and this particularly happens where we're dealing with balancing demands, if you can't get your balancing demand out, then you can serve that Section 20B2 notice. It stops the clock running and gives you time then to serve your proper demand afterwards. So not to fall foul of the 18-month rule, you either need to serve a contractually valid demand, and I stress contractually valid for reasons that I'll come on to, or serve your Section 20B2 notice. You need to do one of those two things within 18 months of incurring costs. Otherwise, those costs are stale, and if they're stale, they're unrecoverable. And the idea behind all of this is that it stops leaseholders from finding themselves in the problems of finding themselves with unexpected bills. That's really where they were coming from when this was devised. So we're talking about West India Key and the recent Court of Appeal case. For those of you who haven't read it, it is rather a lengthy decision. And there has been, and if you read the judgment, you'll see this from the judgment, there's been a history of litigation between the parties. And the judgment talks about that history of litigation, how the parties have ended up where they have in the Court of Appeal. So I'm not going to go into all of the background and what the service charge is related to. That's not relevant really for our purposes today or for the point that I want to get across. But the main issue that I want to talk about today and to tell you about is this issue of, does there need to be a contractually valid demand? In other words, must a demand for payment of service charges comply with the service charge provisions in the lease? Must it follow the relevant contractual machinery contained in the lease? Now, this case, just to touch on very briefly, concerned switch to standing charges. And those switch to standing charges had been demanded from the lessees, but they've not been demanded as a service charge. They've been demanded as a charge under other provisions in the lease. They've been demanded under a covenant to pay outgoings rather than under a covenant to pay service charges. So that's how they had historically been demanded. And back in 2016, this case was before the upper tribunal, and the upper tribunal said that those demands under a covenant to pay outgoings were invalid. And what the landlord therefore tried to do was to reallocate and say that, okay, if the demand for outgoings doesn't work, then let's reallocate and say that these are service charges instead. They should, as I say, have been demanded as part of the service charge. That didn't happen. Didn't happen within 18 months of the cost being incurred, and it certainly didn't happen thereafter. As I say, that there was that reallocation to the service charge in 2016, but that reallocation wasn't accompanied by a fresh demand in accordance with the service charge machinery in the leases. But in any event, by then, the 18-month time from the cost being incurred had long since passed. And the Court of Appeal looked at whether there needed to be a contractually valid demand for these to be service charges and payable as service charges, notwithstanding that reallocation that had taken place. And what the Court of Appeal said is that they had little hesitation, quoting from the judge there, in concluding that a demand for the purposes of Section 20B1 must be a contractually valid demand, which is served in accordance with the service charge provisions in the lease. So this case, albeit that it's a long case and touches on other issues as well, but the main thrust of this case for our purposes is that it is a reminder, if we needed one, of the importance of reading, understanding, and implementing the terms of the leases. So following that service charge machinery that's set down by the lease, because Section 20B, the 18-month rule, applies to, there's an overlap and an interplay between the contractual restrictions on the recovery of service charges. So you must have a contractually valid demand, and you must follow, therefore, the service charge machinery that's set down by the lease. If you don't do that, that could well be fatal to your ability to recover the service charges. So read your lease.
Yep.
It's a short message.
Read the lease, and also have a sort of mental alarm bell going if you're allocating a claim from other than service charge to service charge, that everything that is required for a service charge demand is appropriately met. I can see the questions the questions mounting up as we went through that. So we do have time at the end. We're going to come back to that. I'm just very keen to move on to what I'd describe as probably the meatiest topic we're going to cover today. And I suspect the reason why a lot of people have tuned in today. So the Building Safety Bill. What do managing agents need to know about the Building Safety Bill, other than it's going to change things pretty materially for everyone operating in the residential block management space? So over to you, Cass.
Yeah, there is an awful lot to say about the Building Safety Bill, which is impossible to cover even if we had the full hour dedicated to it. We would be talking for the rest of the day, and I never know whether that's a threat or a promise. The main thing that I want to I suppose, to get across more than anything is that this is something that you will need to look into in more detail. I can give you an overview in the next 20 minutes or so, but it's purely an overview. After today's webinar, go and read about it, go and read the bill itself, book onto courses that deal with this. You need to understand the changes that are going to probably come into play in relation to the Building Safety Bill, and I can't possibly do it justice. We can't possibly do it justice in the time that we have today. So please do carry on to look at this after today's webinar. Because we are time limited, I'm going to look at certain things with the Building Safety Bill. I can't even begin to scratch the surface of what the bill does. So I picked out and selected what I think are the most interesting or the most relevant stuff. And for our purposes, as I say, it's a scratch of the surface, and it's a massive surface. So please do go and continue your research about it after today's webinar. Building Safety Bill imposes a regime, more onerous building safety regime in relation to high-risk buildings. And that regime relates to the design and construction of those high-risk buildings. So it's the regime that applies in relation to design and construction, and also during the occupation of those high-risk buildings. And I suspect that one of the questions that has already come in is, what's a high-risk building? I can tell you. Clause 62 of the Building Safety Bill, and this is a draft Building Safety Bill. It's not law yet, it's a draft piece of legislation, but it's clause 62 of the draft bill that defines what a higher risk building is for the purposes of part 4 of the bill. And part 4 of the bill is the part that's concerned with buildings when they're occupied, and it's part 4 that creates the role of accountable person and building safety manager, which is the kind of things you're interested in. And clause 62 defines a higher risk building as a building in England that is at least 18 meters in height, or has at least 7 stories, and contains at least 2 residential units. So that's what a higher risk building is. And that's what the bulk of the Building Safety Bill applies to. I say bulk because it does have other application as well, and I'll touch on that towards the end of this. And clause 2 of the bill establishes the Health and Safety Executive, so the HSE, as the building safety regulator, so that in practice, the building safety regulator will operate as a division of the HSE. And there are various elements to the role of the building safety regulator. And that role is going to involve things such as the building safety regulator implementing the new, more stringent regulatory regime for higher risk buildings. They will oversee the safety and performance of buildings. They will assist and encourage compliance among the built environment industry, and that kind of thing. They're elements to the new building safety regulator's role. The new building safety regulator has enforcement powers, and those they're able, as a result of that, to enforce obligations under the bill. And the ebook that you will receive after this will set out in some detail what those enforcement powers are, but it includes the ability to exercise new powers to prosecute offences under the bill and also the Buildings Act. What I would flag at this stage is that offences are committed by the body corporate, because we tend to be talking about body corporates in this kind of context, and they may also be committed by officers of the company. So have a look at that. And the regulator is able to issue compliance notices, stop notices, and failing to comply with a compliance notice or a stop notice is going to be a criminal offence, punishable potentially with a prison sentence. The bill, and what I want to look at particularly, is higher risk buildings during occupation. There's lots of information about the lead up to that, so prior to occupation, but for our purposes today, let's look at higher risk buildings during occupation. And the provisions for higher risk buildings during occupation centre around two new roles that you're probably familiar with, and these are terms that you will have come across. They're the roles of the accountable person and the role of the building safety manager. And in addition to that, the bill imposes obligations on residents as well. And I use the term residents, not leaseholders, but residents of that building. If you fancy a read, then have a look at paragraphs 55 to 73 of the explanatory notes that sit around that, which cover the bill's regime for buildings during occupation. If you want to have a read, there's where to go to have a read. So let's unpack what I said there about these two new roles of accountable person and of building safety manager. The duty holder regime that applies during design and construction of a higher risk building continues throughout occupation. And the duty holder during occupation is known as the accountable person. And that is going to be either an individual, partnership, or body corporate. And there may be, and probably is going to be, more than one accountable person for a building. So you will have potentially multiple accountable persons. And this was a bit of an issue that we talked about when the Building Safety Bill first came out last year, in that, well, how it's written is that you can have multiple accountable persons. Each accountable person has to appoint a BSM. Are we going to have multiple BSMs? They seem to have addressed that in that they have come up with this concept in the new bill of principal accountable person. So yes, you can have multiple accountable persons, but one of those must be identified as the principal accountable person, and it's the principal accountable person who appoints BSM, etc. There are still some issues with some of how some of the wording works. Not quite perfect, but to address that problem of having multiple people, it's a bit like the Spartacus moment, isn't it, where everybody says, I'm Spartacus. We have now principal accountable person. And all accountable persons, and indeed responsible persons in a building, have a duty to cooperate with one another and also with the principal accountable person. And that duty to cooperate is backed up with enforcement and sanctions in the event that people don't do that. And the accountable person must do certain things. So the first thing that the accountable person must do is register the building with the regulator and obtain a building assurance certificate. Can't occupy the building until it's registered. The accountable person must appoint a building safety manager, so BSM, and must inform the regulator of that person's identity. The accountable person must assess the building safety risks relating to the building and take all reasonable steps to prevent the occurrence or control the impact of a major incident resulting from those building safety risks in or around the building. And that's the accountable person's key duty. And they're going to demonstrate that they're complying with that key duty by compiling and maintaining a safety case report. And your safety case report is essentially a document that demonstrates that your building is safe for occupation. And your accountable person reviews it, maintains it, and submits it to the building safety regulator when requested to do so. So the accountable person complies with its statutory obligations on an ongoing basis. And if it doesn't do it, then your regulator is going to take enforcement action for non-compliance. So it's important that the accountable person does do that, and there are criminal offences attached to the accountable person if the accountable person doesn't comply with their duties under the Building Safety Bill. One of the things that I said that the accountable person has to do is to appoint a building safety manager. And the building safety manager, or BSM for short, is there to support the accountable person in the day-to-day management of fire and structural safety of the building. So we're not just dealing with fire, which is what we sometimes think where we're talking about the Building Safety Bill, but we're also dealing with structural safety as well. And the accountable person has duties in relation to both, and the building safety manager is there for the day-to-day management of those fire and structural safety matters in relation to the building. And the BSM is appointed by the accountable person, or if you have multiple, the principal accountable person. It might be an organisation, might be an individual, but they will need to be competent in order to carry out that role as building safety manager. I mentioned that residents have duties. They do. So a resident of a higher risk building or an owner of a residential unit in a building mustn't act in a way that creates a significant risk to building safety risk materialising, mustn't interfere with safety equipment that's in the common parts of the building, and they must comply with an accountable person's request in relation to request to assess the building safety risks in the building and take steps to prevent serious harm. There are powers that an accountable person has in relation to residents' duties, including the ability to apply to the court for court order in certain circumstances of non-compliance. So if there are difficulties in getting across the threshold, that kind of thing. One of the questions that I get asked a lot about is, well, who's going to pay for all of this stuff? And we have the building safety charge. The building safety charge looks a lot different now under the new draft of the Building Safety Bill to what it looked like originally. It has been pared down considerably. And what can be included within the building safety charge and what it covers looks a lot different now to what it did prior to this new draft of the bill being published. So it's changed significantly since last time around. In addition to the building safety duties that are implied into leases, both on the part of the landlord and also on the part of the leaseholders, we have further covenants that are implied into leases in relation to building safety charge. So these will be implied into the existing leases that we have. And what the building safety charge does in a nutshell is that it enables the landlord to pass on the running and management costs of the building safety duties to the leaseholder, creates a separate regime. So these aren't service charges, these are building safety charges separate to the service charge regime. And the Building Safety Bill will allow those building safety charges to be demanded from the leaseholders as a building safety charge. And those building safety charges, as I say, relate to running and management, so that the cost of the BSM, the cost of putting the safety case report together, the cost of taking court action in the event that a leaseholder or a resident doesn't comply. Those kind of things are what's included in the building safety charge. So it doesn't include the costs of any remediation works that may be required or building safety stuff like that. So that's different, as I say, from how it was last time. If you want to have a look at specifically what's included, as I say, that list of things like preparing the safety case report and the like, it's Schedule 7 to the bill, and it's proposed that Schedule 7 to the bill will become a new Schedule 2 to the Landlord Tenant Act 1985. There are, in the same way that we've looked at a few minutes ago, statutory restrictions on the recovery of service charges. There are going to be, or there are proposed to be, statutory restrictions on the recovery of building safety charges. So we have a new 47A in the Landlord Tenant Act 1987 regarding identification of landlords for those purposes. We have a requirement to serve various notices and the like. So the statutory restrictions that you are used to with service charges, there are similar restrictions that are proposed to be there in relation to building safety charges. Remediation works. Clause 124 of the bill proposes to insert a new section 20D into the Landlord and Tenant Act 1985, and that relates to the recovery of remediation works costs. You'll all be familiar, no doubt, with section 20C of the 85 Act. The draft Building Safety Bill proposes to introduce a new section 20D of the LTA 1985. And it's all about remediation works. A little unfortunate that the term remediation works hasn't been defined in the bill. The definition is coming in a statutory instrument that will follow the bill. You'll see if you read the bill, if you haven't already done so, that lots of the, I say good stuff, but lots of the good stuff is going to come in separate regulations down the line. And the definition of remediation works is one of those. And what the new section 20D does is that it provides protection for leaseholders by requiring the landlord of the building, and this applies to all buildings, this isn't just higher risk buildings. New section 20D requires the landlord of a building who intends to carry out remediation works to firstly take reasonable steps to ascertain whether any grant is payable in respect of those remediation works, and if it is, to obtain it. To take reasonable steps to ascertain whether any monies can be obtained from a third party in connection with undertaking those remediation works. And if they can be obtained from a third party, then obtain them. And also to take any prescribed steps, further prescribed steps, to any other prescribed kind of funding. And that will come later in regulations. So this might include claims against an insurance policy, buildings insurance, indemnity policy, or warranty. Might include taking reasonable steps to ascertain whether a claim could be made against the developer or designer of the building. And I'm expecting that there will be guidance issued on what those reasonable steps are going to be. But certainly it seems there is some obligation on the part of the landlord to explore alternative cost recovery before just putting remediation costs through the service charges. And if a landlord fails to do that, fails to explore those alternative routes to cost recovery, then under the new section 20D, leaseholder is entitled to make an application to the tribunal for essentially what will become a section 20D order, that those costs of remediation works aren't to be recovered by the service charge mechanism. So it operates in the same ways to what section 20C does at the moment. That seems to be an important one, Raj, that people haven't really been talking about a lot at the moment, this new section 20D.
It's, I guess, sort of stepping back across it, it feels like it's going to be an incredibly busy time for managing agents, but also lawyers. It's as if the rules of a sport have been changed partway through a season and everyone's waiting to see how the referee is going to interpret those rules. do you, I guess there are lots of things you can speculate on around this, but do you think people are going to take a relatively defensive approach? So, for example, issuing claims against residents, leaseholders, being a subset of residents, for non-compliance to protect the position of the account or the principal accountable person? Do you think that that's how people are going to go, or what sense are you getting from the market on what market practice will be?
It's really difficult to tell with it being in draft at the moment and subject to change. I mean, we've had a lot of changes from last time out to this time around, and there's still a long way to go with it as well. So I suppose that's an important point to emphasize, put my teeth back in, that this is a draft. So what we're talking about now isn't in law. You don't need to rush out today and start making your Section 20D applications. But these are the kind of things that are being talked about that are coming down the track. So that's why it's important that you know about it. Just to deal with that Section 20D point, I mean, I'm a massive fan anyway of preemptive applications to the tribunal where other people's money is being spent, because that's what service charges are. I probably foresee a lot of applications to the tribunal by landlords saying, we intend to incur these costs. Can you please tell us that it's reasonable for us to do so? So
Yeah.
Dealing with that potential Section 20D challenge. I think it's also important as well, and this will come out in the ebook that people get, is that the Building Safety Bill proposes to amend certain parts of the fire safety order. So historically, we've thought about Building Safety Bill applying to higher risk buildings, and Fire Safety Order and Fire Safety Act applying to buildings containing 2 or more sets of domestic premises and keeping them separate. And there are elements of the Building Safety Bill, as I say, that don't just apply to higher risk buildings, but have an application across the board. That Section 20D that we've talked about is one example of that, but there's also examples where it's proposed to amend Fire Safety Order.
Thank you. Cass, I'm conscious of time because we've got a couple of quick things to tick through, and we've had a slew of questions coming in. I've just got one request to audience members. If you could take 1 minute at the end of today's webinar to provide feedback. I'm really interested in, do you find the general primer, like the general meeting, or for example, if we did one on what a valid service charge demand has to contain, is that useful to you? Is more about the building safety bill and what's coming down the track more useful to you? Please take a minute at the end to provide feedback. And Cass, very quickly, in light of the number of questions, EWS updates, what's happening there? Is there any, I know that I'm being asked quite a lot about it by clients, so what's your sort of high level synopsis of where we are?
I'm being asked about it a lot as well. It's an ongoing issue, isn't it? And challenge for anybody involved, whether you own, whether you're looking to buy, or whether you manage properties. It's one of those issues that doesn't seem to go away, does it? We had Jenrick's speech on the 21st of July, where he talked about government having taken expert advice in relation to the risk of buildings in the UK. And that expert advice concluded that fires don't often spread beyond room of origin, so lenders shouldn't be acting like there are widespread and systemic issues here, and said that the EWS1 form should no longer be requested by lenders where leaseholders are trying to sell in blocks below 18 metres. Perhaps open to the audience as to whether they're seeing any benefits of Jenrick's speech on the 21st, whether the requests for EWS ones have head off a little bit, or whether they are still getting them for blocks below 18 metres. It would be interesting to see how the market is responding to that now that we've had a few weeks for it to settle in.
The sense I'm getting from speaking with people before we move on to open consultations is lenders still view it very much as a lending decision, and unless is probably the right way of putting it, there is a retirement of the consolidated advice note. There doesn't seem to be any particular change from lenders around their appetite to proceed without the EWS one. But again, not being a practitioner, this is second, third hand information from across the market. Is that what you're hearing as well, Cass?
Yeah, it is. That's pretty much reflective of what I hear as well.
Okay, so it'll be love to get the feedback from the audience. Is it useful to keep giving you updates as this goes, or are you so deep in living through the pain that you don't really want to hear about it from anybody else? Entirely up to you. I'm just going to go on to open consultations, and Cass, I guess this is a sort of battle cry, a call to arms for the managing agents on the call. So over to you.
Yes, you have until the 15th of September to respond to a consultation on the draft PAS standard, and it's PAS 8673, which is all to do with the framework for competence of individual building safety managers and nominated individual building safety managers. There are some concerns within industry regarding the PAS as it's currently drafted. So it is a cry for help, you guys, to have a look at the PAS and to respond to that consultation. The concerns are centered around the PAS standard because that seems to exceed the competencies that would be required of a building safety manager than those that are set out in the building safety bill. So the building safety bill and the draft PAS standard don't quite align. Have a look if you have opportunity to do so at that new PAS standard, that draft PAS standard, I should say, rather than new PAS standard, and to give your feedback in relation to it generally, but your feedback in relation to it specifically about the competencies of the building safety manager would be greatly appreciated. I know that ARMA's position, and indeed the position of others on the PAS steering committee, are that the PAS should be redrafted. You have an opportunity to have your say, and please have your say.
You'll also, as part of the follow-up email to this webinar, receive links to all the open consultations that you may want to provide input into from the perspective of practitioners.
Yeah. You will be involved in the management of buildings. It may be that across your portfolio, some of those are higher risk buildings, either as accountable person, BSM, nominated individual, whatever you are. But do take a look and respond to that PAS. Its key issue is specific competencies.
And we're now going on to, with the remaining time, and I've done my best to keep us vaguely to time, the section that I call Ask Cass. So we're going to do our very best to run through things in the order in which they came up in the webinar. And we're going to take the themes that have come from the questions that have been asked. And I appreciate that this typically leads to additional questions, so we'll crack into it. So the first is developer leaseholder handover. I think this goes to your point, Cass, about reading the memonarts and understanding them. An interesting one, where the memonarts state that the developer directors will resign and hand over the RMC to the leaseholders on the sale of the last flat. What happens if the last flat isn't actually ever sold?
That normally tends to feature in the leases rather than in the memonarts.
Yep.
Have a look at your memonarts and see what your memonarts and your leases are saying in relation to that. But the trigger is the sale of the last flat, isn't it?
Yeah. If that doesn't happen, then the trigger hasn't been achieved. 18-month rolling service charge recovery. A lot, probably more questions on this than anything else. And I think there is one thing, which is if the audience wants a primer on this, please provide feedback, which is how do you make sure that the contractual requirements and the statutory requirements for demands are met? So what is a valid demand for service charge? I would summarize as being sort of half the questions have been asked. Who picks up the shortfall if the in funds, if the section 20B isn't complied with? Is it the managing agent, management company, the landlord? But basically, where do the costs go that have been incurred but can no longer be recovered?
Okay, take those ones in turn. You need to look at your lease. Your lease will tell you what the contractual restrictions are. So you need to make sure that you're demanding in accordance with your lease. Your lease will tell you what, for example, what percentage, the fact that the service charges are payable. Your lease will tell you whether they're payable in advance, in arrears. There's lots of things that you should be looking at in your lease. And it's probably best if you wanted this to look at that as a kind of 10-minute primer at the start of the next one of these webinars, and we can look at the kind of contractual restrictions. The one where people fall down, and where if I see people falling down, this is where it is. It's on those contractual preconditions. So your lease will tell you what needs to happen before that service charge is payable. Generally, they focus on accounting related stuff. But if your lease says, and I always give this stupid example, but if your lease says your service charges must be demanded on pink paper with purple spots, then you must go out there and buy some pink paper with purple spots and demand your service charges on said pink paper with purple spots. Because if you don't, those service charges aren't payable. And we know that the 18-month rule applies to on-account demands for service charges. And we know that you have to serve a contractually valid demand. If you don't, and you don't spot it quick enough, then those service charges become stale, they're not payable. And you end up with a raft of unrecoverable service charges. Now, as to who picks up that black hole of unrecoverable service charges, well, it's the landlord, i.e. the person who's entitled to enforce payment of service charges, that isn't able to recover that 10 grand, 50 grand, 100 grand, whatever it might be, depending on the size, extent, and length of your mistake. That landlord may well go knocking on the door of the managing agent, suggesting that the managing agent has been negligent, because in the contract that the landlord and management agent have, the agent has agreed to comply with legislation, in particular 85 Act and 87 Act, and has agreed to demand service charges. So it then becomes a bit of a bond fight, potentially, between landlord, and as I say, landlord in this context is the person that's collecting the service charges, and the managing agent, if the managing agent has been negligent in some way. Important, read, understand, and implement, to look at your specific leases. Just because you do it one way for a specific block doesn't mean that the block next door will operate in the same way. We know that leases differ from block to block to block.
Thank you, Cass. We're going to jump onto the building safety bill, where there have been various questions. So just on that last section, I think a lot of the questions are about what constitutes valid demands, and I think that's a topic in and of itself. But again, let us know if that's of interest to you. I think you cover this off, but does the building safety bill apply to EWS1 defects or missing items in terms of applying a claim to the initial developer? In fact, you didn't. I misread that question. I'm going to come back to that. Sorry. We've covered off the examples of obligations set out on residents. Is there an equivalent to the Building Safety Act being considered for Scotland? I have no idea of the answer to that. Do you?
No idea. No, as a lawyer, we get admitted to the role in England and Wales, and Scotland's entirely different. No idea whatsoever in relation to Scotland. Apologies to our Scottish friends.
A very good question again, where I think you sort of covered it, which is part of the building safety bill applies to buildings of less than 18 meters or fewer than 7 stories, if I've got that sort of conjugation correct. Which bits of it, or is there a primer, or is there somewhere people can look? So a managing agent on the call says that constitutes the majority or perhaps all of their buildings. How do they find out which bits apply to them? Is there any signposting that you can provide?
No, it's intermixed. A lot of it is intermixed. It's probably towards the end of the bill more than in the main body of the bill. So towards the end, before you start hitting the schedules. But that's not to say that there's not stuff before that that applies. What I would say is go and have a look at the section 20D that I've talked about, and the ebook that you'll get will give you the reference to the clause for that. And also go and have a look at the fire safety order stuff, which is clause 134 of the bill. I say a lot of this tends to come towards the end of it before we hit the schedules. So it's clause 134 that proposes to amend the fire safety order. That's probably a really good starting point, because that talks about amendments to the fire safety order that are going to require things like responsible person to record their fire risk assessment, and person appointed to assist the responsible person must be competent, responsible person having to record their fire safety arrangements. So a lot of important stuff and a lot of important changes that are proposed to fire safety order. So have a look, if you haven't already done so, at clause 134 of the bill. The bill's shorter these days than it was. I mean, it was originally over 300 pages. We're now down to 200 and something pages. So it's lost a bit.
Hopefully quick question, which is, will the BSM be appointed on an annual or other basis? So no idea.
No idea.
Right? And from speaking with clients, some of them are looking to run the function internally where they're at sufficient scale. Some of them are looking to join forces with others and create a source of collection. Some are looking to outsource. I just don't think there's an industry. There are a few questions here about what will industry practice be. We just don't know yet, unless you've seen an operating model out there. And also questions about training requirements. So how will the training gap be filled for BSMs? How are we going to attract people into that role? It's highly skilled technical role. And obviously we've talked about the costs of the building safety management element being passed back to leaseholders. I would say that I haven't seen appropriate answers to how they will be appointed, trained or recruited anywhere yet, but it's coming down the track.
It is. And I'm part of an organisation called the Building Safety Alliance, which is designed to provide a register of certified BSMs and nominated individual BSMs. So it's a register of registrants, so far as that's concerned. So if people are interested in that, then have a look at Building Safety Alliance. It's not for profit, and it comes off the back of Working Group 8 and all of the stuff that they were doing. But that's why, again, it's so important to, going back to that draft PAS, that people respond to that they have a look at what the framework and competencies are proposed to be for the BSM, which don't align with what the Building Safety Bill says, and that you have your say in relation to that. Do you think the competencies and framework is correct? Do you think it's too wide? Do you think it should be narrowed? What do you think? Tell them now while you've got the opportunity.
And the link to that will be in the follow-up email, so please do click on that link. A slight tangent, but an important question. So from an audience member, I understand there's a new LPE form currently in the works. Is there any indication of when this will be available or implemented?
Don't know as to when it will be available. I can't imagine that it will be in the too distant future. I think it's coming. I've seen it, so yeah, it's coming, not too far away.
Thank you. Finally, apologies if we didn't come to your question. So some of them we will wrap into follow-up material, some of them into a follow-up webinar. Just the comments coming in on whether people are still being asked for the EWS1 forms. Not that many responses. Hopefully we'll get some more at the end of today, just so we get a sense of where the market is. But the crux is, yes, they are still being requested for buildings of below 18 meters.
It goes back to what you were saying, doesn't it? It's a lending decision.
And lenders are naturally risk averse. They're not taking the upside of a commercial endeavor. And so until they get until the retirement of the consolidated advice note, I can see them continuing along that line. Cass, thank you so much. This has been a deluge of wonderful information. To everyone in the audience, thank you very much for giving up your very valuable time. If you'd like to know about future webinars or other materials, please do follow us on all good social media channels. And if you have any feedback, I'd ask that you take 30 seconds at the end of today. We need your feedback to know what sorts of topics are most useful: primers, deep dives, insert whatever term you want. Please just give us your feedback so we know the whole purpose of this is to add value and help you as much as possible. You can watch any historical webinars at thefixo.com/webinars on our website. There's a drop down there, and we have various about the Building Safety Bill, but they were discussions of the previous drafts, just as that. So today's webinar is of the most recent draft, and recognizing, of course, that most recent draft may also change. So just keep watching it, keep thinking, get prepared. And with that, thank you all so much for joining today. Really appreciate it. And we look forward to seeing you on our Q4 legal and compliance update. Give us a steer on what you'd like us to talk about. Have a wonderful day, everyone. Thanks.
Take care, everyone.